How to prepare for a federal bond hearing. If you are concerned about a federal bond hearing, obviously there's already been a circumstance where a person has been charged or is going to be charged. They're going to go through an arraignment where they learn the charges against them, and then they'll have a chance to have a bond hearing, usually in front of, at least in South Carolina, in front of a magistrate court judge. At that bond hearing, several factors are taken into account, but generally speaking, it's risk of flight and the seriousness of the charge or the danger presented to the community. Now, it's always helpful to have a thorough understanding of the facts in a case in order to argue against, or at least present to the court, arguments against what the government might say. And the problem is, in the majority of cases, there's limited information. Someone's just been arrested or just been charged, and the discovery or the evidence in the case hasn't been turned over yet. So there are times where it makes sense to waive that initial bond hearing, preserving the right to have it heard later. Take the time you need to review all the evidence so you have full arguments, and then have that hearing heard 2 to 3 weeks later when you can be fully prepared with the evidence. So one way to sort of prepare for a bond hearing is simply to get all the evidence possible before arguing that hearing in front of the court. A second thing that's important is to make sure that you have a full group of people there who can help you. Family, friends, anyone who can speak to the ties to the community, work background, whether there's kids that have to be taken care of, all of the things that show there's ties to the community, and also that the person's not a danger. So lack of criminal record, character, and those kind of things. So the first thing I would say is you need to be fully informed of the facts, try to get all the evidence. And second, make sure you have folks there that can speak to character, risk of flight, and ties to the community. Finally, having an attorney who has spoken to your family, who has spoken with the individual who's charged, is very important. Doing a bond hearing the same time as an arraignment at the time of arrest can be difficult because the attorneys just simply don't have enough information. So getting in contact with an attorney early, taking the 2 to 3 days that might exist between the arraignment and the bond hearing, or waiving it temporarily to get that information is helpful. The more information counsel has to argue for an individual, the better the chances are. So bond hearings happen quick. They don't have to, though. First option is to waive it and come in later with the evidence, and then always make sure you're ready there with family and friends who can speak to character. If you have any questions about a bond hearing, about what goes into those determinations, please give us a call. Our number is 843-473-7000. Thank you.